good.
Okay. Carrie, do you want to start?
Yes, I'll get started here. Well, welcome everyone. Thanks so much for joining us today. I'm Carrie Sonmore with the Battered Women's Justice Project, and I'm here today to assist the Clearinghouse with their webinar. So before we begin, I'm going to briefly go over some of the logistics for today's webinar. If you are disconnected from the webinar at any time, just go back to that original email and click on the Join link again. If you need any help rejoining, you can call iLink Support. You can reach them at 1-800-799-4510. And I just typed that into the chat box for everybody. You'll find this chat box on the left lower hand corner of your screen. To use this feature, put your cursor in the white rectangle all the way at the bottom, left click, enter your text, and then hit the Enter key on your keyboard to submit your text. All participants are muted throughout the whole webinar, so please use this chat feature for any questions, comments, or problems that you may have. If you do run into any technical problems, I ask if you could please send me a private chat. To do so, click on the gray Private tab that's to the right of the Public tab in the chat box, and then double-click my name, which again is Carrie Sonmore, and then a box will open up for you to send me a private message. Why don't we all try out the public chat? Looks like a lot of people already got it going, but if you could just let us know where you're joining us from today, and if you have a group of folks, how many people are with you? That'd be great. And while folks are doing that, for anybody who's only on the phone portion today, you can email me with any questions, and I'll make sure to get those over in the webinar today. And you can reach me at ksonmore@bwjp.org. We are recording this webinar today, and you'll be able to access this on the National Clearinghouse website in about 7 to 10 days. Also, shortly after the webinar, we'll be sending out an email that will have a confirmation of your attendance. It will have a brief survey, and I believe it will have a link to where your recordings are going to be posted. Is that correct, Sue?
That is correct.
Okay, great. And with the survey, we'd greatly appreciate any feedback that you could give us. We definitely would use that. And then any folks that are only on the phone, you won't automatically receive that confirmation. So if you could please send an email requesting that if you'd like one, I'll make sure to get that out to you. And I think that covers everything for me, so I'll send it over to you, Sue.
Okay, thank you so much, Carrie. Good afternoon, everyone. I'm Sue Ostoff, and I'm with the National Clearinghouse for the Defense of Battered Women. And I really want to extend a warm welcome to all of you. And thank you very much for joining us on this webinar. And this is the second in our what will become a series of webinars about expert witnesses in cases that involve survivors of battering, sexual assault, and other forms of trauma. I also hope that you have received the announcement for our upcoming webinar scheduled for May 13th. And that one is titled Considerations for Aspiring Experts at Community-Based Violence Organizations, Domestic Violence Organizations. And that's going to be done by staff at the Iowa Coalition Against Domestic Violence. If you haven't yet received that information, it was going out earlier this week. Just to know, we're working really hard to get these announcements up on our website. We're trying, BWJP has a mailing list that they are sending our announcements out to. And so if you're not on the BWJP mailing list, you can get on by emailing Carrie to get on that mailing list. And please watch for announcements for our future webinars. I want to thank the Office on Violence Against Women for the support of this project of expert witnesses, and I also want to extend my very sincere thanks to Carrie Sonmore and our other colleagues at the Battered Women's Justice Project in Minneapolis, where it is snowing again, for their continued and really truly excellent help and support with our webinars. So, as you know, today's webinar is titled Testifying as an Expert Witness, Understanding the Role of Experts in Different Legal Arenas. And our presenter today is Cindine Pizzell, and it's my pleasure to introduce her today. And for those of you who listened in to our first webinar in this series, you know that Cindine is the legal coordinator here at the National Clearinghouse for the Defense of Battered Women. And we've been really fortunate to know Cindine for a long time. She was actually an intern with us here at the National Clearinghouse during her law school years. and then she became a public defender here in Philadelphia. And during her final year as a public defender, Cindine had a rather unique gig. She actually practiced exclusively in family court as a public defender, providing criminal defense to people accused of crimes involving the violation of a civil protection order. So she came to us with some really unique sets of experiences that have been very, very helpful to us and to the people that we're assisting. So she came to us in 2008 and rejoined us as our legal coordinator. And in addition to coordinating our legal team, Cindine provides technical assistance to defense teams. She does research, she develops legal materials, and she conducts many training programs. She's also the lead staff on our Expert Witness Project, the one that's funded by the Office on Violence Against Women. And it's in this capacity that she's been attending a lot of different trainings by state domestic violence coalitions and national organizations on how to be an expert and how to present expert testimony. She's been in a unique position of having an opportunity to interview numerous trainers and very experienced experts, and she is developing resources designed to increase the availability and effectiveness of expert testimony for victims of ongoing battering. And Cindine, and by proxy me, has been learning tons from all the trainings that she's attended, all the readings that she's done, and all the people who have generously shared information with her. And I just want to give a shout out because that really includes our project partners with this OVW project on expert testimony, and those are people at the Iowa Coalition Against Domestic Violence, and in particular Lori Schipper and Kirsten Faisal, and they will be the two who will be presenting the webinar on May 13th that I mentioned earlier. So we're really glad you joined us today. As Cindine will talk with us about some core concepts of the legal system generally. She'll also talk about the importance of understanding the goals, the purposes, and elements of the different legal arenas in which experts testify, and really look at the kind of the issue of what is an expert and what an expert is not, and also discuss the different types of testimony an expert may be asked to present. And we were kind of thinking about this, and we're wondering if people will go like, oh, I know all this stuff already. I sure hope you'll stay on, because one of the things that I've come to understand by working with Cindine over the past 8 months on this project is that some of this so-called basic stuff is actually pretty complicated. We're seeing that it's often misunderstood by a lot of different players and professionals in the field, and it's just really important to have this foundational information when working as an expert. So we do hope you'll hang with us for this. For those of you who may have joined a little later, I just want to introduce Carrie Sonmore, the Battered Women's Justice Project in Minneapolis, and I am Sue Osthoff with the National Clearinghouse for the Defense of Battered Women, and we're your hosts for this webinar today. And before we hand this over to Cindine, we just want to ask you a few questions. So I'm putting these, okay, Carrie, I may need your help.
Okay, I'm here. I cannot control it myself, so I'll just have to talk you through it.
Okay.
Okay, so double click on the
Maybe Cindine,
polling.
could you go to the next slide, please, first?
Sure.
Okay. We're going to ask you some questions. And so what we want you to do is actually to answer the questions on the screen, the little dots that will appear. And then, and two other questions, in question number 1 and question number 4, there is a place where you can say other. And then if you check other, then and only then do we want you to fill in your answer in the chat box. This will get easier once we have the questions up, and Carrie's going to have to help me get them up.
I am here.
Okay.
So go ahead and double click on the polling questions in that content tab.
Okay.
And then under the first one, you'll want to, what does it say again? I think it says ask question or display.
It says ask all questions.
No, further, well, yep, you can do that all at once.
Okay, why don't we just do it then? Okay, so right now we're on the very first one, which is how do you describe your profession? So if you could click right there on your screen for those of you who are participating through iLink. And for those of you who are only on the telephone, you're not going to be able to answer these questions. Okay. It looks like we're getting a pretty good results here. And if you check other, if you can fill in, excellent. Some of you are doing that over there in the public chat. That's really great. Okay, we'll just give this another minute or so, or even less. Okay, it looks like some people are still filling in other. It looks like almost half the people on this call are community-based advocates. And then we've got about 16% that are clinicians, social worker, and therapists. All right, so let's go down to the next question. And if you describe yourself as an expert witness on battering and its effects, or an expert witness on sexual assault or other forms of trauma, what we're trying to get here is that if you call yourself an expert witness, do you also work as a community-based advocate? Or do you not work as a community-based advocate? So this is for the pool of those of you who call yourself an expert witness. Okay? So it looks like about 20% are saying that they're experts and community-based advocates, and then 6% are experts and not community-based advocates. These numbers don't add up to 100% because it's actually, they take the numbers based on the total number of participants, which is 107. So that's why the numbers are weird. Okay, you've gone down, people have gone ahead and answered these questions about OVW grantee, and if you can fill in the information about what kind, that's great. And you are going ahead and filling in the other as well. So that's great. Let's just give another couple seconds here, and then we're going to just move on. Thank you for doing that. It's very important information for us to have, so thank you for taking the time. We really appreciate your patience there. Okay, let's go back. Now, okay, Carrie, before I hand it over to Cindine, is there anything else that you want to add?
I don't believe so. Maybe just remind anybody who just joined that all participants are muted, so you do want to use that chat feature for any questions or comments.
And just about our questions and comments, basically what we'd like to be able to do is we're going to be monitoring the public chat during the webinar, and we'll keep track of your questions, and Cindine will talk for, as long as she needs, and then the time at the end, I will be asking your questions. So we're not going to unmute people. So if you have a question, please put it into the public chat box, and like I said, we'll do the best we can to get to all the questions. We might not be able to, but we will try to figure out a way of following up with them in future webinars. Okay? And so now it's my pleasure to hand it over to Cindine, and I'm going to put her photo up there, I think. There. Cindine's on top now.
Great. Thank you. Thank you so much, Sue. Oh, hi, everybody. I'm so glad to be talking with you today about some of these really fundamental pieces that it's so important for people to understand if they're considering testifying as an expert witness in the legal system. Now, what we want to do today is really to back way up and make absolutely no assumptions about what folks do and don't know about the role of an expert witness, but more importantly, really, about the fundamental concepts involved in the criminal legal system. You're going to see that we're going to need to move pretty quickly because there's a lot of information here. There's a lot of words on the slides that I'm probably not going to get a chance to say out loud, but that is by design. We have done that to enable you to go back and use this PowerPoint as a resource. In particular, some of the examples that are contained within the slides of the different things that we're talking about here. So please do go back to this. Now, I want to stress that we don't expect that folks, especially those who are completely new to the legal system, are going to walk away from this webinar knowing everything they need to know about it in order to navigate it well as an expert. But it is our hope that you will all get a sense of the sorts of things that you need to know in order to be able to do your job as an expert witness most effectively. And we just want to be clear that today is not the day for skill building or for learning how to do voir dire or for learning really important things that you need to know about working with the attorney who hired you. We are going to be talking about those things, but those things are going to be featured in future webinar series. So if I hope you weren't expecting those kind of skills-based things or domestic and sexual assault content stuff, because we're not doing that today. Like I said, we're really backing way up and talking about some fundamentals here. Sue gave you some idea about why we thought it was important to include this particular piece in this training series on expert testimony. So I really do want to share with you some of the things that we have learned as we have moved forward through this expert witness project. Advocates and other potential experts that we've talked to have a really wide range of experience with the legal system. There can be people who have been testifying for a dozen years who have really, really different levels of knowledge about the way that courts work and the way the law works. And then in particular, we have seen that people who may have a lot of experience in one area of the law, like in criminal court, for example, don't necessarily know a lot about other areas, so that when they move into other systems, that can create a lot of confusion. One really experienced expert I spoke with recently, she's been testifying for 20 years. She said, every time I walk into a different courtroom, it's a brand new day. So really that's what we're hearing, that's what we're seeing, and that's why we want to kind of nail down some of these fundamental concepts for folks. We've also talked to a lot of people who have been doing this for a very long period of time that really wish they would not have had to learn it on their feet. They wish they would not have had to go through the trial by fire, and that somebody would have given them some of the basic fundamental building block information before they ever started testifying as an expert witness. And we also want to say that, when I say that our goal today is to not make any assumptions about what people do and don't know, that's because we've seen in operation the fact that lawyers especially, they're so involved in the legal world that they really make a lot of assumptions about what potential experts do and don't know. And I've given some examples of some of those things on the slide here. And then, finally, just about some language stuff. We're really going to be pretty consistent with our language today. And whenever you're talking about the legal system, it's important to do that. And fundamentally, what we really have to remember is that a victim of ongoing battering can be any party in any case. And so what the court terminology deems them, whether they're a complainant or a defendant or a plaintiff or a petitioner, that's not going to reveal whether somebody is battered or not. So we're really going to try to use some consistent language so that it's always clear when we're talking about a victim of ongoing battering, or when we're talking about a complainant, or whether we're talking about someone else. So the beginning is probably the best place to start, as always. So let's talk about what an expert actually is. An expert is a person who has a special set of skills and or knowledge in a particular field. I think it's probably fair to say that everybody on this webinar is an expert in something. An expert and an expert witness aren't necessarily the same thing. An expert witness is somebody who has that kind of specialized knowledge that others, for example, members of a jury, typically don't have. And they're called to give that testimony in a court of law about the matters within her area of expertise. So it sounds like a total no-brainer, and maybe it is, but the take-home point here is that just because somebody out there in the world is an expert in something doesn't necessarily mean that they're going to make a good expert witness. And that developing expertise on domestic violence, sexual assault, trauma, stalking, other things, having expertise in those things doesn't necessarily mean you're going to have the kind of skills it takes to be an expert witness, okay? One does not necessarily imply the other. Both things are things that need to be learned. You know, Bernie Madoff here, he's an expert in Ponzi schemes, but as an expert witness, we think he probably has some credibility problems. So, you know, when I was going through this, I'm like, should I explain what testimony is? And then I'm like, you know what, I really do need to, because it's just, you know, people who are going to give testimony in court know that what they're doing is going in to a room to give some folks some information, and I think we all have that. But what we don't necessarily have is that we're not free to do this however we want to do this. You know, expert witnesses and potential experts know that their job in a court of law is to educate the court, whether that's the judge or the jury. But they're not going to necessarily get to do that in the way that they think is going to be the most effective. There is an awful lot about the presentation of testimony in court that does not feel natural. We've heard this from experts over and over again. For example, an expert witness, you know, has all this information that tells them that a particular subject is extremely important, but, you know, the lawyer that they're working with tells them, oh, you're not going to be allowed to talk about that. Or on the flip side, experts often have to answer a bunch of questions that they don't necessarily think are all that relevant to the issues in the case. So testimony, it's one of those things that we all know what it is, but we really need to understand the complexities of it so that when we go into court and get on the stand, we're not surprised by how bizarre it ends up being. So as I said, people who give testimony can't get on the stand most times and talk about the information that they feel is most pertinent. They're giving their information by responding to a really unnatural feeling series of questions by at least two different attorneys. And they might not get to talk about the thing that they thought they were there to talk about. It feels very bizarre. And then the other piece of it is, you know, I think that when we all live our daily lives, you know, we have an expectation that we should be able to conduct our communications with people in ways that feel comfortable and safe and normal to us. But when expert witnesses are on the stand, if they don't like the questions that are coming at them, they kind of can't just get up and walk away. So sometimes you have to deal with hostility. Sometimes you have to deal with condescension. And as I said, it's just not necessarily something that feels completely natural. I want to be clear that, you know, there are going to be situations where expert witnesses walk into court and they're kind of given some free rein. You know, the judge wants to hear what the expert has to say and doesn't necessarily have an interest in putting any restriction on how that's going to go forward. But people who have experienced that need to know that the next time they go into court, they might be bound by a bunch of rules and procedures that feel like they're coming out of nowhere. So really, this is about the expert I spoke to who said every day in court is a brand new day. That's really the point that we're getting at here. Just remember that, you know, if you have the skills to teach a class or you have the skills to have a conversation and educate somebody about domestic violence, you very well may be an effective expert witness, but giving that testimony is usually not going to be exactly like teaching a class or having a conversation. And in fact, it probably is going to feel pretty darn unnatural. There's also a lot of rules. Of course, there's a lot of rules. And, you know, we're not going to take up your time by going over the zillion rules today. And quite frankly, the lawyers that you're going to be working with, you know, really need to take the lead on figuring out what you can talk about, what you can't talk about, what the other side is going to have a problem with, and those kinds of things. But really, this is just to know that there's a lot of strings being pulled behind the scenes that are going to have an impact on what you can and can't talk about once you get into the courtroom. We're going to talk about witnesses for a minute, and there's a very specific reason that we're doing this. We've heard from several communities about community-based advocates who are being asked to testify, and they're not necessarily being given enough information to know what they're being asked to testify about. In other words, they don't know if the lawyers who want to call them as a witness want expert information or if they want fact information. And I just want to be clear, it's not that the advocates that we've talked to don't necessarily, they probably know the difference, but the lawyers that are asking them to testify don't really know what they're asking for. So knowing the different possibilities can really help people who are asked to testify ask the right questions when they get that phone call or when they get that subpoena in the mail. So two types of witnesses. Let's start with fact witnesses. Fact witnesses are called to give testimony of information they possess because of something they observed or something they experienced. Okay? Something they observed or something that they experienced. Now, fact, the word fact has its own connotation, so we just want to be clear. Fact in this context doesn't always mean an irrefutable truth like 2 + 2 = 4. Testimony on facts talks about observations, perceptions, experiences of the person on the stand, things that they actually have personal knowledge of. Okay, so I bring that up because sometimes when people get on the stand and give a version of events that the other side disputes is true, even though that testimony might not be true, it's still technically called fact testimony. Okay. We do know that advocates and other domestic violence and sexual assault professionals are asked to testify as fact witnesses sometimes. And what the lawyers in those situations are looking for is some personal information that they have about a survivor. Now, I really want to be clear that we're not saying, oh, this is a great idea to get on the stand and talk about personal information you have about a survivor. So yeah, responding to subpoenas could be a whole other webinar. The point here is really that advocates and other folks who do give this kind of testimony, they may very well be experts, but this is not expert testimony. This is fact testimony. Now, here's some examples of what advocates testifying as fact witnesses may be talking about if, in fact, they do get on the stand, which we're not trying to say is a good idea. They might talk about a survivor's attendance at a counseling group. They may talk about some injuries that they observed on a survivor. Maybe the advocate overheard a threat that a survivor's abusive partner was making in a courtroom. These are examples of fact testimony that may be given by people who are expert witnesses. So on the other hand, expert witnesses are people who are testifying based on their knowledge, and that knowledge has got to be something that the average person normally doesn't have. The definition that I have on the screen is the shortest one I found, and that's courtesy of Google, which is my favorite source for everything. It's important to say that expert witnesses in many jurisdictions are called opinion witnesses. And it's important to be clear that in this context, opinion has a broader meaning than how we usually think of it. When I think of the word opinion, what I usually think of is a personal preference for something that is neither right nor wrong. Who is the best internet cat of all time? Should George Clooney wear a beard? That kind of thing. But we're really talking about somebody's conclusions that they arrive at based on the experiences that they have, their specialized knowledge, their training. So opinion is really expert opinions that are reached that could not have been reached without the expertise of that witness. Now, it's, this may seem like a minor point, but it's important to talk about. Expert witnesses can't just give opinions on anything in the world. It really does have to be on something that's within their particular area of expertise, and it has to be something that most people don't know about. Okay, so you can't just to bolster one's case, one couldn't call an expert witness who happened to be wearing a fancy suit to talk about what the red traffic light indicated, because most people know that. An expert is not going to be allowed to talk about that. Yeah. So it's important to really talk about how domestic violence, sexual assault, and other forms of trauma are uniquely situated when you're trying to think about and learn about the differences between, what's in what's a special area of expertise and what's known to most people. Because domestic violence and sexual assault, they're things that a lot of people, judges, the general public, they think they know it. So that makes it complicated. If you're bringing in a DNA expert, people know that they don't know how to analyze DNA. But people don't know that they don't understand domestic violence and sexual assault. And I bring that up because we do hear about lawyers and other people attempting to use expert testimony in their jurisdictions, and they encounter barriers. And that's because people don't necessarily understand that they don't understand this. We know they don't understand this, but they don't know they don't understand this. And part of the lawyer's job that you're working with is going to be able to communicate to the court exactly why they don't understand this. Now, I'm going to be talking a little bit more about this as we move along, but I want to just have this clarifying note about opinions given in court about domestic violence and sexual assault. And there's so many times that an expert could walk into court, and based on her knowledge and experience, she probably can figure out exactly what happened to the survivor in that case. But there's a lot of rules about what experts can and can't talk about. For example, an expert is almost not ever going to be allowed to talk about whether or not a particular witness is telling the truth. And that's one of those things that feels kind of fundamental. But, as you become more and more involved in this work, you'll find that there's a lot of gray area here where an expert's opinions might be challenged because they get too close to talking to the court about whether or not a witness is actually telling the truth. Okay? So fundamentally, it's important to keep in mind that we're, as experts, we're not going to usually be allowed to talk about veracity. We're also not going to be allowed to get on the stand and say, in my expert opinion, the defendant is totally and completely guilty and should be sent to prison immediately. We're not allowed to opine on the guilt or innocence of defendants in criminal cases. Does it happen sometimes? Sure, it does. But it's important to keep in mind as you move forward that most of the time you're not going to be allowed to do that, and you need to be having conversations with the attorney that you're working with about what the bounds of your expert testimony is going to be. And then along those same lines, a lot of experts find themselves in court responding to hypothetical situations. Miss Jones, would you be surprised to learn that a battered woman had left her abuser X amount of times before XYZ? That kind of thing often happens, but if it looks too much like the facts in the case that's actually happening in court, it might be precluded because it really is getting too close to whether somebody is telling the truth or lying, or whether somebody's guilty or innocent. So as you move forward, if you see lines being drawn in what you can and cannot say, these are some of the reasons why. So here's some examples. I try not to qualify every single thing I say, but I say probably here very deliberately because we know that a lot of different things happen in a lot of different jurisdictions. But again, these examples are for you to come back to as you're moving forward with learning about this issue. Please keep in mind that the laws are very different from jurisdiction to jurisdiction about what kinds of opinions are admissible. We really do hear things totally across the board, okay? And, you know, it's not your job to have the law memorized, but it's going to really help you in your career as an expert witness to have an understanding from the lawyer that you're working with about what the rules are. You know, the less challenged you are about what you can and can't say, I think the more comfortable you're going to be, for sure, and probably the more you're going to be believed, quite frankly. Now, there are people who serve as fact and expert witnesses in the same case. I think the most common example that I can think of are SANE nurses. They may give some fact testimony about findings of a forensic examination, but separately they may also be asked to testify about some general concepts about domestic violence or sexual assault that they know about because their career, you know, is all about sexual assault. So that's an example. We've seen police officers who may be involved in a case because they were the first responder to a scene, or because, you know, they're the ones that put the handcuffs on the defendant. If they also happen to be domestic violence experts, we've seen people in this situation give both fact and expert testimony in the same case. Now, except under rare circumstances, an advocate expert who does have personal knowledge, or in other words, could give fact testimony about a particular survivor, should not serve as an expert witness in that survivor's case. And this point is probably going to be made over and over again in future webinar series. I really hope you're all able to join us on May 13th, where you're going to hear a lot about the pitfalls, that a lot of which I'm sure you can already anticipate, about giving testimony in a survivor's case when you actually have personal knowledge of that survivor. So once again, rules, okay? When I talked about before about all the strings that are kind of getting pulled behind the scenes that are going to influence what experts can and can't do, this is another place where that happens. There's a lot of fundamental things that need to occur before an expert is even allowed to get on the stand and testify in court. Not every time. Sometimes everybody's just going to agree that yes, this expert is an expert and the testimony is relevant and it's admissible. But other times there's going to be hours and hours and hours spent trying to argue that the witness that the lawyer wants to call is in fact an expert, that what they're talking about is helpful and relevant, and that the things that they know, the things within their area of expertise, they know about based on reliable methodology, okay? So like if you've worked with 4,000 battered women, that's probably going to be viewed as reliable, whereas, you know, there's not been a lot of court buy-in to predictions made by crystal balls and tea leaves. So methodology can be important too. So, you know, talking about this today is all about making sure that people aren't surprised when they go into court and they face some barriers with what they are going to be allowed to talk about. So we're going to shift a little bit here and talk about 3 different court systems. One could argue that there's more than 3, but really the vast majority of expert testimony that occurs on domestic violence, sexual assault, and other forms of trauma happens in these 3 systems. I know that there's a lot of people probably wondering why knowing the details about these different systems can be useful. You know, you're not being called to be a legal expert, you're being called to be an expert on domestic violence. Well, as we were talking about in the beginning, really experienced experts can be stymied by getting really experienced in one court system and then moving into another and realizing that all these differences are tripping them up in a major way. Also, knowing the purpose of the court system that you're in is a really good way to help inform experts about not only what to expect, but what their role is going to be in that particular proceeding. And finally, once again, we find ourselves in a situation where our areas of expertise, domestic violence and sexual assault, are particularly tricky to navigate, because for the people that we work with, there's a lot of overlap between these court systems, and so we always have to know how to figure that out. And a lot of the folks that we worked with are involved in multiple court systems at once. Those are the realities that we're dealing with. So the better we are at sorting those things out, the better job we're going to do. Another really experienced expert that I had the opportunity to talk with for a little while last week said that new expert witnesses need to understand that they're playing in somebody else's sandbox. And I wrote that down because I thought that said it pretty succinctly. Whenever any of us are out of our professional element, we really need to know some of the building blocks and some of the rules if we want to be as effective as we can. So, I'm doing this whole, like, what are experts? What is testimony? What is court? Well, a court's function is to apply and interpret laws. And the only reason that a court does that is because there is a controversy or a problem that is brought in front of it. Every state has a court system. The federal government has its own court system. Most of the tribal nations have their own court systems as well. Here we're really going to be focusing on trial level courts. Okay, that's the first level where a case gets heard usually. And the reason we're focusing on trials instead of talking about appeals and other things is because that's where the vast majority of expert testimony takes place, is at the trial level. Now, laws are rules, okay? Simple as that. Laws are rules that are grouped by what they cover. This is compared to my other ones, this is a fairly short slide, but I'm going to spend a little bit of time here because I think some of the nuances that get lost here. Get lost in understanding the fundamental differences between criminal law and civil law. So, criminal law is there to enforce rules, and these rules prohibit certain acts that are deemed to harm society as a whole. Criminal law governs actions that the community decides are against the public good. Okay? Criminal laws can change over time. Laws can be passed. Laws can be canceled. There's a lot of things that are illegal today that weren't illegal a number of years ago, and vice versa. So criminal law is a very fluid piece of law, and it really reflects what lawmakers believe are against the public good or against the public interest. Okay? When I give some examples a little bit later, we're going to be getting back to that. But compare that concept to what civil law is. Civil law is not about acting to protect the public interest. Civil law is about protecting the rights of private citizens and coming up with private remedies when laws that protect private citizens are broken. Okay? Once again, we're talking about protecting individuals, not because what happened to them is necessarily harmful to the public good, but because it's harmful to them as an individual. Okay? I hope that becomes more clear as we move forward. And then finally, administrative law, which, it's an area of civil law, but we wanted to pull it out because it really does look different for expert witnesses in this context. Administrative law governs how rulemaking bodies work. Okay, so if there's a rulemaking body out there like Immigration Customs Enforcement or an unemployment board that has the power to affect the rights of a particular individual, administrative law is there to make sure that that individual is treated fairly and within the bounds of those particular rules. And you know, I know that I said that in about 20 seconds. I took an entire semester course on this in law school. It's complicated stuff, but it's an important distinction for our purposes, because when we go in there and we give expert testimony, knowing what the expert testimony is there to do is going to be what makes us effective as experts. So we will definitely start here with criminal court and kind of talk about how the mechanics of that work. Criminal court is a place for people who have been accused by the government of breaking certain kind of rules. And they were the rules that I mentioned before, rules that when broken go against the public good. I mean, we know what these crimes are, right? You know, there's a million of them, you know, murder, rape, theft, robbery, all these different things. Now, in order for there to be any kind of sanction or punishment of that person, the government has to affirmatively prove that the person they're accusing actually did something wrong. You know, it's not enough to make the allegation. They have to go in and they have to prove it, okay? Here's you know, this is not an exhaustive list, but I wanted to give you some features of criminal court. And there's a million features of criminal court, but I pulled these out because these are what make criminal court look different from the other systems that we're talking about. When you're in a court of law, a criminal court of law, there's two sides. One side is going to be the government, okay? And you know, whatever government is bringing the allegations, they're going to be a party to the case, okay? So in criminal court, there's never going to be two private parties. It's always going to be a government against one or more private individuals. And the way that that government gets represented is by a prosecutor. Prosecutors are almost exclusively unique to criminal court, okay? So if you're working with a prosecutor, you're definitely working in criminal court. Now, the next point is one that our experience in working on this project bared out the importance of talking about. And that is that in criminal court, if the defendant cannot afford to hire his or her own attorney, one gets appointed to represent her in almost all circumstances. There are some exceptions to that, but for the most part, indigent defendants get court-appointed attorneys. Okay? This is unique to criminal court, and we'll talk about why that's particularly important a little bit later, but basically, sometimes we hear from advocates and experts frustrations around how batterers are entitled to free lawyers and battered women never are. Okay, and that it's understandable why that confusion happens, but knowing the difference between criminal and civil court can really help explain you know, why you're seeing a lot of batterers with free lawyers and why maybe you're not seeing as many survivors with free lawyers. Now, in criminal court, there may or may not be a complainant involved. And if there is, she's a witness, not technically a party. So when a prosecutor hires an expert witness, that expert witness is an employee, basically, of the prosecutor. That if there's a survivor or a victim involved in that case, you know, it's not their case. So, you know, when you hear something like, oh, the state picked it up, you know, what that usually means is that whether or not a particular complainant wants to proceed with a case, the government is going to proceed because they don't need the complainant sign-on to proceed in a case. So, a lot of prosecutors' office will really work with complainants to figure out whether or not to move a case forward, but they don't have to, and that's kind of the takeaway point for that bullet. In criminal court, the government can and does use its resources and power to enforce laws and carry out punishments. Now, we know that in some cases they don't do this nearly effectively enough. In other cases, they tend to overreach. But this is I'm bringing up this in the context of criminal court because it's unique to criminal court. The government really, you know, kind of really does have the power to prosecute its cases as it chooses. But that being said, because they have that kind of power, they have a really high burden. They have the highest standard in the law because by design, this criminal legal system is not supposed to make it easy to punish someone or to send someone to prison. So that's, the government's power and resources are supposed to be balanced by its really pretty hard job that it's supposed to have. And then the system is set up to where if there's little or no evidence that a person broke the law or violated a criminal rule, the government isn't even supposed to be able to bring them into court. We know sometimes they do, but the way that the law is designed is that you have to really have a certain amount of information that somebody broke the law in order to bring them into court. Again, it might feel like a minor point, but these are really the things that make criminal court unique, and the things that if you hold them, they can help you make the distinctions when you're in criminal court versus when you're in civil court or in administrative court. Now, the goal of criminal court is really to determine whether a charged person is guilty or whether they're not guilty. And as I stated before, it's always the prosecution's job to prove that that defendant is guilty, and it's never the defendant's burden to prove she is not guilty. So, the side that calls an expert witness and then the kinds of questions that they ask, an expert's job can be made easier by keeping this in mind. We've seen expert witnesses get hired by the defense in criminal cases, and they do a whole bunch of prep, and they're all ready to go, and they're really invested in the case, and the case goes forward, and then the defense rests without putting on a single shred of evidence. And the expert is in this place of feeling like a survivor of ongoing battering may just have been, completely railroaded. But the fact of the matter is the lawyer may have done that because they didn't have to prove anything, and they really felt like the prosecution didn't successfully meet their burden. So keeping this goal in mind can be something that's really useful. We already talked a little bit about language. Again, this slide is for you to go back to and to just keep in mind that somebody's designation in the courtroom is not going to tell you whether or not they've experienced ongoing battering. Now, we've already talked about, the way that the government tries to enforce laws that affect the public interest, and that's criminal court. So civil court's different. Civil courts are really set up to settle disputes. And those disputes may, most often come between two or more private individuals. Sometimes there's entities or organizations. It's confusing, but sometimes the government can even be a private party. But basically what we're doing here is trying to settle disputes that the parties could not otherwise settle, okay? And unlike criminal court, where the goal is to decide whether somebody's guilty or not, the goal in civil court is to resolve a dispute, is to get rid of a dispute or a problem. In civil court, there isn't a prosecutor. Even if a party was technically a victim of a crime, in civil court, there's not going to be a prosecutor, okay? And each party is responsible for getting their own attorney if they want one. So here's where you're definitely going to probably see a lot of survivors without attorneys. Incarceration is not going to be a possible direct outcome of a civil case. Like you can't sue somebody in order to send them to jail. Might somebody end up in jail for other reasons? Sure. But the goal of civil court can't be to put somebody in jail. Now, when I say a party doesn't need probable cause to sue someone, what I'm really saying is that an individual doesn't have to have a government sign-off in order to bring somebody into court to say, look, I got a problem and I need it resolved. You can't just haul somebody into court whenever you feel like it, but you don't have to have that kind of government approval. And then the language piece, there's some variation to this, but in general, the person bringing something into court is going to be the plaintiff, and the person responding to that is going to be the defendant. And again, those tags are not going to tell you who's a victim of ongoing battering and who's not. Now, it doesn't, we know based on the survivors that we work with that civil court can feel extraordinarily punishing and can affect people's life in fundamental ways if they get a huge monetary judgment against them, if they lose custody, if they lose their house. They can feel very punishing. But keep in mind, as an expert witness, the goal of civil court is not to mete out punishment. It's to figure out whether one side has been unlawfully harmed by the other side, and if they have, to fashion some kind of remedy that makes the harmed party as whole as possible. One version of that, when there's not kind of a tangible judgment that can go from one party to another, it might be just a problem that needs to be solved. A court can do that too. The example that might be most relevant to all of us is child custody. Both parties disagree about what to do about child custody, and so the court hears a bunch of information, and they may land on one side, they may land on the other side, or they may fashion a resolution that wasn't what was proposed by either side. So sometimes it's not necessarily figuring out whether one party has been wronged by the other party, but by solving a problem that needs to be solved. And then the other thing that can happen in civil court is to stop a person or a company usually from doing something illegal. That's called an injunction. The person who's trying to stop the other person from doing something illegal might not get an affirmative benefit like money or something like that, but what they will get is for somebody to stop their bad behavior that's harmful. Okay. Now, administrative courts I find extraordinarily confusing because there's a million of them and they all look really different. So I tried to make this as succinct as I possibly could. Just keep in mind that administrative courts are really there for oversight. They're really there to make sure that agencies follow their own rules, and that if agencies are making decisions that affect individuals, that individuals have a chance to have their side of the story heard. They can also be a place for people to go to ask for certain rights or benefits or privileges. So for our purposes, we're real. The big examples where we really do our work is in immigration court, in public housing, in employment licensure, public benefits, these kinds of things. These are administrative bodies, and expert witnesses can be really good assets for survivors in these contexts. Now, I have on here that there won't be a jury. There won't. But you never know who's going to be the decision maker. It might be a board of people. It might be one people. It might be one person. It's probably going to be less formal than other forms of court. Sometimes the rules of evidence apply. Sometimes they don't. But what we hear in the field is that it's usually pretty relaxed. In civil and criminal court, you can make some fundamental assumptions about what you're going to see from one courtroom to another. Here's the judge, here's the jury box, this and that. Immigration proceedings probably aren't going to look very similar from proceeding to proceeding. So like if you have some experience doing immigration work and then you go to testify in a workers' comp proceeding, it might be a completely different ball of wax. So even though they're both administrative bodies, they're not necessarily going to look the same. And we've heard from testifying experts in the field that sometimes this can be a really good place for new experts to get their feet wet because the rules tend to be fairly relaxed, and because of that, new experts can feel less pressure. Okay, so in a nutshell, those are the three kinds of courts that it's really important for experts to understand the building blocks of. I've been talking about expert testimony in a really general way, but I want to make a couple of distinctions here because there's a lot of ways that expert testimony can be presented, but really all the methods fall into two categories. And we're going to be coming back to this chart, and again, I invite you to revisit it after this webinar so you don't have to memorize it now. But the two types that we're really going to be focusing on today are victim-specific testimony and general testimony. Some people refer to that as generic testimony. Victim-specific expert testimony involves an expert providing specific information about the actual case being tried in court. That expert walks in knowing a lot of information about the case that is in court. They're usually, though not always, forensic evaluators, have a background in psychiatry or psychology or social work or something where they can do forensic evaluations. And they come to specific conclusions about the specific issues and parties in that case. Okay, so the example I have here is an expert who might be determining for the court that the defendant meets the criteria, the diagnostic criteria for PTSD. That is victim-specific expert testimony. It's not generally about victims, it's about this particular victim. People who give this kind of expert testimony come up with their information in a number of ways, and different experienced experts have really different practices and preferences about the kind of information they need to work on a case. But one of the things they probably will do is interview the survivor. They will probably review all the documents that the attorney has. They might even ask for additional information. We talk to experts who sometimes go out on their own and get additional information. They might provide a written report or a forensic evaluation. They may speak to other people who are either involved in the case or know the person. And in some circumstances, depending on that person's expertise, they might administer psychological tests to that person. And the results of those tests can sometimes have a direct impact on what the expert's opinions are going to be when they walk into court. So when you go back to your chart, you will see the different contexts in which victim-specific expert testimony can be and is presented. And so we're just going to talk about when it's not, okay? Victim-specific expert testimony is almost never used by the prosecution in a criminal case. And yes, I know that I qualified stuff again. I used the word almost, but it's really true. We have heard of some exceptions to this, but I think it's a good rule of thumb to say that experts presented by prosecutors are almost always giving general testimony, even if that expert who takes the stand actually has specific information about the victim in court. There's a ton of reasons for this, but the one that stands out most to me is that if an expert witness were to have information from the complainant in a case in order to come to an expert opinion, the complainant then has to be, the defense has to be allowed to examine the complainant. And as I'm sure you all know, there's a million reasons why that can be a particularly bad idea. The rules of evidence might not allow this anyway. And I wanted to make sure I wasn't talking out of school, so I contacted our colleagues at Equitas, which is the National Prosecutors Resource Center on Violence Against Women, and they confirmed, yes, in fact, victim-specific testimony offered by the prosecution is not a practice that they endorse. General expert testimony. I want to be clear that general expert testimony, some people kind of think of it as DV 101, and I think it's okay to think of it that way, but it can be a little bit more specific than that. Experts providing general expert testimony are going to be asked questions about concepts that are relevant to the case that's in the court, okay? But what they're not going to be asked are specific questions about the case in court, okay? So here's an example here. Say you're dealing with a case where you know that one of the issues the jury is going to have is that the complainant stayed with her abusive partner, and therefore she might be lying about being battered. That's an issue that's relevant to that case in court, but you're not talking about that particular victim's reasons for not leaving her abusive partner. Okay, I hope that's clear. I'm sorry, I accidentally hit my mouse here. Okay. Experts who give general testimony like this have varied practices for determining what they need before they decide to testify in a case. We've talked with a lot of people with a lot of different practices, and we're going to be talking about the pros and cons of these different methods in future webinar series, because I think there's a lot to be said for each one of these methods. Okay. Some experts that we talk to who are giving this kind of general testimony may have done almost as much as somebody giving survivor-specific testimony. In other words, they may have read every single document that the attorney has on that particular case. On the flip side of that, we've talked to a lot of experts who go in cold. They have absolutely no information whatsoever about the case that's in court, and the only sense they're going to get about the issues that are relevant to that case is by the questions that are asked of them by the attorney who called them in the first place. And then sometimes it falls pretty much in the middle. This is probably, I would guess, the most common. They have a summary of the case from the attorney who is calling her as a witness. And again, we're going to talk about the ups and downs of all these different ways. Here's this fancy chart again that I promised you would be showing up. I do encourage you to come back to it as a way to help sort these things out. So let's talk about what domestic violence sexual assault experts actually do in criminal court. Now, unlike the other two court systems we've discussed, there's a few fairly predictable ways that domestic violence and sexual assault experts might be used in criminal court. If they're used on behalf of the prosecution in an action against someone accused of harming his or her partner, they're being used because the prosecutor thinks that there's aspects of the case that will not be understood by the judge or jury without expert testimony. Now, it's important to keep in mind that that's the prosecutor's call. The complainant may or may not be involved in the proceeding at all, and the expert may or may not know whether the victim is involved or whether the victim isn't involved. Okay? So some of the most common examples of testimony in this context that we know about are experts talking about recantation, experts talking about minimization, experts giving reasons why somebody might refuse to testify against their abusive partner, those kinds of things. There's a lot of areas of expertise that can be relevant for the prosecution, but those are the ones that we tend to see most often. On the other side, domestic violence and sexual assault experts might be called on behalf of a defendant because that attorney believes that her or his experiences of abuse will be relevant and helpful to support his or her side of the case. So on behalf of the defendant, a wide variety of information might be able to be presented that is going to help the judge and or jury have additional context, cast a particular light on the defendant's decisions and behavior and state of mind in a way that is helpful to that particular defendant. And then another way that we sometimes see experts used in criminal court is just as a way to rebut the findings or testimony of an expert who's testifying on the other side. So we tend to call these experts adverse experts, and this could really go a couple of ways when there's an adverse expert. An adverse expert might have access to the same kind of information that the expert on the original side had access to when they came up with their opinions, or they might get on the stand and talk about all the reasons why the other expert doesn't know what they're talking about. Or, they might do both, quite frankly. Now, in civil court, this is an issue I've been working on for quite a while. I've really been trying to come up with a neat unmessy way to describe the different ways that domestic violence and sexual assault experts are used in civil court. Unlike criminal court, there's really no good way to do that. Experts are used all over the place for all different kinds of things. First of all, they might be hired by any side. They might be called to give either general or victim-specific testimony. They might be called to talk about recantation or minimization or those other things that we talked about. Or they might be called to talk about a specific area of battering that's somehow relevant to that particular case. In addition, they might be called because there was a court-appointed expert, like a custody evaluator, who was particularly problematic. They might be called to talk about why battering doesn't necessarily make somebody a bad parent, or being battered doesn't make somebody a bad parent. So I really couldn't pigeonhole that one in a way that was all that helpful. Just know that it's so important, if you're being asked to testify in civil court, to be clear with the attorney what it is that they want you to do. And like I said earlier, sometimes attorneys don't know what they want you to do. So being able to brainstorm about the different possibilities is something that is really going to increase your effectiveness. Now, this slide is just here for some examples. I think I gave them pretty much all already. Now, in administrative court, here's some examples. We know that domestic violence and sexual assault experts get involved quite frequently in U or T visa proceedings. So they may write a report, they may give testimony. There's different ways that can go, and that kind of depends on which particular immigration hearing you're in. This is another example where one courtroom is not going to look like another courtroom. We know that experts testify a lot in the state of Texas, but I was talking to an expert in California who says that most of her immigration work actually is based on reports that she writes. So new courtroom, different day. An expert might testify on behalf of an employee who is trying to explain that she shouldn't lose her license just because she got arrested, because that arrest was a direct result of domestic violence by her abusive partner. Or another example that we see all too often is expert testimony in housing situations where a battered person is about to be evicted based on something that his or her abusive partner did. And so expert testimony in those situations can be really helpful and crucial. Now, I've been really talking about testimony, but experts don't necessarily have to ever give testimony. An expert might be hired as a consultant only, or even if they're hired as a potential expert, they may not end up testifying. But they're still involved in a case in a way that helps to move the case along, to educate the lawyer, to help uncover information and to brainstorm about areas of domestic violence and sexual assault that is going to be helpful to that particular case. So even when I use the word witness, we're really talking about expert services where there may or may not be any testimony. Future webinars are going to talk about role and the importance of being clear on one's role in a particular case and the implications of those roles. And what I mean by that is consultants are not bound by the same kinds of rules that witnesses are. So what an attorney does or doesn't have to turn over to the other side is really going to depend on what the expert's particular role is. That's a little bit beyond the scope of today, but it's important to just know that that distinction is there. So let's wrap up so we have a few minutes for questions. A lot of this stuff, there may be a question of why you need to know it. We know that experts who do know it feel more comfortable. Okay. We know that experts who have firm grasps on these fundamental concepts will appear more credible to people on the outside looking in, and they're going to be better prepared. There's also going to be a likelihood that there's easier communication between you and the attorney that you're working with. If you speak that language at least a little bit, that relationship is going to be more beneficial to the survivor who is going to be benefiting from your expert services. You're going to have a much easier time figuring out which aspects of a particular case are of particular importance if you know why the case is in court in the first place. And then this last one I think is particularly true, and we hear it from experts over and over again. If you don't have to sweat the small stuff, you can do a much better job on why you're actually there, okay? So the more information you go in with, the more opportunity you really have to not work on trying to understand these nuances, but to actually provide the information that you're there to provide. And just like any other world, knowing the language and culture and organizations of any of the systems that you're working in are going to help you be a more effective expert. Sue.
Thank you so much, Cindy. That was really great information. A lot to think about. Okay, we have about 10 minutes, a little over 10 minutes to finish this up. And let's see, we're not going to be able to get through all these questions, but a couple of them came up early, Cindy, about how victim advocates could answer questions on the stand. And in the chat, I said we'll probably address this more specifically when we get to more of the how-to skills-building ones.
Yes,
but I don't know if you want to just weigh in. I mean, here's the question that came, and we, if we need to punt it to a later one, I think we can. But I think it's good to just review. The question was, as a victim advocate on the stand, how do you respond when the defendant's attorney asks if you as an advocate believe every victim? And then the advocate said yes. He used it against her because how does she, the advocate, know 100% that the victim is telling the truth? What is the best response without dismissing that you as an advocate believes everything? It's a loaded question. And then LaTanya weighed in to say that's happened to her before. I'm just wondering if you want to address that now or if we should put that in the parking lot for later.
I think we could do
both.
I was just going to say, I think we can do a little bit of both. This is something that comes up at most trainings that I've been at as a particularly important pitfall to keep in mind when advocates are testifying as expert witnesses. It can be really effective method to undermine a victim's credibility, and I think it's important to talk about why. When an expert gets on the stand and says that her expertise is based on working with 1,000 battered women or other survivors of domestic violence and sexual assault, the lawyer can challenge the information that the advocate has learned by working with those 1,000 victims by implying that the advocate doesn't actually know whether or not all those victims were telling the truth. So by going along that particular course of cross-examination, attorneys can really effectively paint the pool of knowledge that the advocate is drawing from. Okay, so one strategy that we've heard really works is that when advocates also have knowledge of some of the social science literature and research in the field that substantiate what they've seen in their jobs, they can use the research to back up what they've actually observed. And that research can be about the substantive issue that you're actually talking about, or it can be about the fact that most people who report violent things happening, it can be about veracity sometimes, okay? Again, you can't talk about whether a particular person is telling the truth, but you can point to social science research to back up your observations as a victim advocate that you're basing your knowledge on. So that's the introduction to an answer to that, and I do think we should revisit it.
Yeah, and some other participants weighed in and talked about whether or not victim advocates are doing assessments. And what does that assessment include, and might that be a helpful route to go for do an assessment about whether someone is a victim of battering or not?
I think victim advocates who do that may also, when that happens, it's because they also have a background that allows them to do that, whether they're a licensed social worker trained in providing clinical services, or maybe they have a background as a psychologist or a psychiatrist or some kind of therapist who is actually skilled in doing this kind of assessing. When I haven't really seen people who don't have those particular things on their resume do these kind of assessments, and I think that it would be pretty problematic to try to get that into court, quite frankly.
So it does sound like it may be something that would be worth coming back to, because another participant said, how do you respond if both partners in a same-sex couple are identifying themselves as the victim?
Uh-huh.
I might say something along the lines of, every client that I work with has gone through an extensive assessment process to be found eligible to receive victim services. So I do think the whole issue of assessment is a huge topic that many of us in the field are struggling with thinking about working on. And I do think then the relationship between doing assessments and expert testimony is something that we should come back to.
I agree, and we should make sure that we come back to that, talking about the different implications for when you're providing general testimony and when you're providing survivor-specific testimony.
Yep. In the broad context
yep.
of what you were talking about today. Absolutely.
Yep.
There's a couple, let's see, well, we couldn't have gone through this conversation without having someone ask us about the Jodi Arias case.
We really could have, people.
So the question is, in regards to expert witnesses, expert witnesses are almost never used by prosecution in criminal cases. Would you be able to say why the Jodi Arias case has included several expert witnesses in the murder trial in Arizona? And Cindy, maybe you can do like 10-second introduction about what that case is about for people who may not have cable TV.
Okay, like myself.
Like me.
But for some reason I know too much about this case anyway. Okay, Jodi Arias is on trial as we speak in Arizona. She's being charged with capital murder for killing her ex-boyfriend. So that's the very, very, very short version. Basically what the defense is saying is that the defendant's experiences of abuse are relevant to why she killed him. It's unclear to me whether or not they're actually saying that she acted in self-defense. I think they are saying that, but I think they're also trying to provide a larger context of what was going on when she killed him. The actual crime itself, the actual incident itself was extraordinarily gruesome, involving multiple stabs, multiple gunshots, and supposed attempt to hide evidence and that kind of thing. So from the defense standpoint, it's a really, really tough case. In that particular case, the defense called 2 or maybe even 3, I'm not sure, experts to provide case-specific information, to talk about Jodi's experiences of battering, and also some, clinical diagnosis about PTSD and these other things. Because the defense did that in Arizona, the prosecutor was able to call these adverse experts to counter the findings that were made by the defense experts. So that's why the prosecutors in this particular case were able to really to provide that kind of expert testimony.
Thank you. Then there were a couple sort of more criminal defense questions, and just looking at the time here, the woman who asked about wanting a further explanation about what beyond a reasonable doubt actually means has gotten off.
Uh-huh.
I don't know, so maybe we should keep going.
Okay.
Unless you want to try that one in 22 seconds.
Yeah, no.
Okay. And I actually had a question, Cindine, about the burden. You said that the defendant never has to prove that they are not guilty. I just, when you were talking about who had the burden to prove a case. And as I understand it in that slide, you actually said that the defendant never has the burden. Is that correct?
Well, initially it's always correct.
Okay.
As a case moves forward, it can definitely shift. And I was trying to, basically what I was trying to say there is, a defendant is never going to be expected to respond to a mere allegation by proving they're innocent. Okay, so before a defendant has to do anything at all, the prosecution has to put up a certain amount of evidence. Now, the burden could shift to the defense at a certain point if the defense is going to try to assert, some kind of justification or excuse defense. So they're not trying to say, I didn't do it. They're trying to say, I did it and here's why. And they may have the burden to prove the here's why piece, but they don't have the burden to disprove the I did it piece. Does that make sense?
Yes, and I think I just wanted people to hear that. So
okay.
Thank you. Because I know we have some experienced people on here, and I didn't want them to walk away thinking that you didn't know that, because I know you do. And just because we're wrapping up here, I just want to acknowledge some of the other questions that we're not going to have a chance to get to, but it's stuff that we really would like to come back to. One of the questions came up, are we going to talk about expert witnesses in juvenile courts? And so that is something that I think would be a good idea to talk about
I agree.
in the future, and we could get somebody to do that.
Yep.
And the woman who asked that said she works in a culturally specific organization, and many of the victims they serve are facing CINA cases, CINA cases.
Oh, I don't know what that means.
I don't know what that is either. If somebody does, if you could, this shows that this is not an area of expertise for us. You can type that in. That would be helpful. Because of child endangerment issues. And our advocates have also been asked to serve as expert witnesses on cultural issues. So children in need of assistance. Thank you, Laura. That was helpful. So obviously we won't do that webinar, but we'll get people who know about that stuff to do that webinar.
Yeah, so that's a great idea.
So it is now 4:30 Eastern Time. I just urge everyone on this webinar to always check what time zone the webinars start in. I can tell by messages we get from our phone service that people call in an hour early, an hour late, and sometimes 2 hours late. So just pay attention to the time zone. We will be posting ours in Eastern Time, but please pay attention to the different times. I also see that some people have asked about other dates. I will stay on for about 3 more minutes and post some additional information in the chat room, but then I am going to get off of that chat because it costs all of us money. So I will post the information about some additional dates coming up. Great. And we only have one at this point. And Carrie, before we get off, is there anything else you'd like to say?
I think a couple of people are asking if this is going to be recorded. We are recording this today, and this will be posted on the Clearinghouse website in about a week. So just everybody knows that. And then also you all, everybody who's joined, you will receive a confirmation of your attendance email as well. And then again, for folks who are only on the telephone, if you'd like that email, just send me an email requesting it at ksonmore@bwjp.org.
And then if you're still having trouble with the Google Docs, you can let us know at ncdbw@ncdbw.org. I'll put that back up. And then if you can put specifically what you're asking for in the subject line, it helps a lot. So just say expert webinar number 2, need materials, and we can get them to you if you're having trouble. Cindine, any last word before we sign off here?
The only thing I'll say is that my email address is up on this slide. So if anybody wants to talk more or has some particular questions or wants to share their experiences or disagrees with anything, frankly, that I've talked about, I really would love to hear from you. This is an ongoing learning process, I think, for all of us, and so I'm looking forward to that opportunity.
So thank you so much for the really excellent webinar, Sandine, and thank you all for participating. And as she said, we really see this as a beginning, and we really hope to continue this conversation for upcoming months. So please stay tuned. Thank you, everyone. Have a great afternoon. Bye.
Thanks so much. Bye-bye.